All right. So again, where does that put us, and who decides? Um, Again, we go back to Wilson's statement. It's not a decision that's made once and for all. It's a decision that each generation makes. It's a decision made because of circumstances. Um, but that does not mean that it's accepted by all. And so this is the dynamic that is being played out. And you have to remember there was no history here with this new constitution and what things actually meant. So they're fighting it out. They're fighting it out with each other, trying to establish what it means. And as part of that component, what happens is the Supreme Court speaks, and it gives their view as to what can happen. So one of the things that happened was states are passing laws based upon their interpretation of what they think their power is, what they think the federal government's power is. Now, as you recall from last week's lecture, we said that Marbury versus Madison was the most important Supreme Court case ever established, ever decided, because it established the Supreme Court's power to review acts of Congress, and therefore also acts of states, and find if they contradict the Constitution that they can declare them void, non-existent. The Supreme Court's second most important decision comes in a case, McCulloch versus Maryland, 16 years later. And that really was dealing with the same issue. Who is supreme, the states or the national government? And so what had happened under this auspices of how we're going to be governed and what we ought to do, states were creating their own banks, as well they should have, as well they could have, under any interpretation of the Constitution. They were creating their own banks. The problem was, at the time in history, there were no banking regulations, and when there was a downturn, many of these banks would fail. And they would lose, of course, all the money that depositors had put in, and also money that the national government had deposited. And so the national government was tired of losing their money. It's not like you can take this tax revenue and go to the White House and stick it under the president's mattress. So they needed someplace safe to put it. So at the time, there were no national banks created by the national government in which they could regulate and make sure they were safe and make sure they didn't lose their deposits. And so Congress had this great idea. Let's make our own bank, and we can make, therefore, we can make sure that it's safe, and we're not losing these deposits we make from the tax revenue that we collect. The question becomes, does Congress have the power to establish a bank, since there is no power specifically granted for Congress to create a bank in the Constitution? Now, this was a big deal, and you can see in this debate that people are still struggling between the Constitution they've created at Philadelphia and the Constitution they had under the Articles of Confederation. They're still hung up on this idea that a power must be expressly granted. There's nothing in the Constitution that says it has to be expressly granted. That was the old Articles of Confederation. Now, then on the other hand, the Constitution does in fact say this, which seems to hint at a limited power for this legislature, this new national legislature. So Article 1, Section 1, all legislative power herein granted. So another legislative power is herein granted. It's not, you don't have all power. All legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. So what is that legislative power herein granted? If it's not herein granted, then they don't have it, is the idea. So that is the dilemma that we're looking at with this issue with the bank. So the Supreme Court is going to speak and give their view on, as it were, this debate. The Supreme Court is headed, at the time, the Chief Justice is a guy by the name of John Marshall. And it's said of John Marshall that he did more to put into effect what the founding fathers had decided at Philadelphia than any single other person. And he did that in his role as Chief Justice of the United States Supreme Court. So the federal government, or excuse me, the Supreme Court gives their answer in McCulloch versus Maryland, and this is one of the things they said in that decision. The federal government possesses only those powers enumerated in the Constitution. So they're seeming to side at the moment almost with expressly granted. But enumerated means numbered or listed. So the federal government possesses only those powers that are enumerated in the Constitution. But, their meaning requires interpretation. There is power to lay and collect taxes, to issue currency, to borrow money. And then Marshall goes on, and the other members of the Supreme Court with him, because they all agreed to this decision. To carry out these powers, Congress may decide that chartering a bank is necessary and proper. Necessary and proper to carry out those powers. Meaning, so they have power to issue currency. They have power to borrow money. What then do they do with that money? What is it that they do? Do they have to take it back to the president's bedroom and stick it under his mattress? No. Marshall says they can decide that chartering a bank is necessary and proper to help them carry out these powers. So he gives an expansive view of this view of the Constitution, gives an expansive view that the necessary and proper clause allows them to do other things that are not specifically listed in the Constitution that will help them do those things that are specifically listed in the Constitution. All right, so there's that. Let me go back to the previous screen and just say something that I neglected to say. So in making their decision, the Supreme Court is really answering a couple of questions. Could Congress establish a bank? That's the first question that they're asking. Could they establish a bank? And the answer that they give here is yes, they can establish a bank. Now, there's a second question going on. So what had happened in McCulloch versus Maryland is when the national government created this bank, when Congress created this bank, the state of Maryland said, no, we don't like this. We don't like this one bit. And so they passed a law that required any bank not chartered by the state to pay a tax, and that tax was $15,000. It wasn't the size so much of the tax, although at the time that was a huge sum of money. It wasn't so much the size of the tax that was being protested. It was the fact that there was a tax at all. And the Supreme Court has really got to address this issue. So in the second part of their decision, they're addressing this issue. Can a state tax the national government? Okay, you can see that better now. So can a state tax a federal bank? Can it be taxed by a state? So in other words, it's more as just I've said. If the state can tax the national government, who then is supreme? That is really the question that the Supreme Court is looking at. And this is what their answer was to that question. The U.S. government is established by the people, not the states. Since the people are sovereign, the federal government is supreme. The only way for the federal government to be supreme is for the powers to be immune from state destruction. The power to tax involves the power to destroy. And since the power to tax involves the power to destroy, the Supreme Court said, no, the state does not have the right to tax a bank created by the national government. In other words, the states can't tax the national government. Or, in a nutshell, in McCulloch versus Maryland, the Supreme Court established the principle of federal supremacy over states, over state law. Now, some of you may be asking yourself this question. Wait a second. I thought that the Constitution was established by the states because, after all, who sent delegates to the Constitutional Convention? It was the states that sent delegates to the Constitutional Convention, not the people. And that is all true. It was the states that sent delegates to the Constitutional Convention. But Think of how the Constitution was ratified. The Constitution was ratified by the people. How did that happen? Well, Article 7 deals with the ratification process, and it gave the states two options. They could do it by a vote of the people in their state, or they could do it by a special convention where people were elected to that ratifying convention. So the Constitution is actually ratified by the people. The people in a state decide whether or not their state was going to ratify it. So you can see here there's elements of both. Both of these views can be seen as correct, depending on the perspective that you're looking at, which allows this play to go on, which allows the flexibility of the Constitution to do what it needs to do. But the Supreme Court at this moment has decided with the view that the national government is supreme over the states. And in this instance, that's really all they can do. The federal government has got to be supreme over the states, or we're right back under the Articles of Confederation. So you would think that the Supreme Court's interpretation in McCulloch versus Maryland would settle the issue, but it doesn't. It doesn't settle the issue. In 1824, just a number of years, just a few years. How many was that? That was, just 5 years after McCulloch versus Maryland. You get this nullification crisis that is precipitated by John C. Calhoun. Now, if you know anything about John C. Calhoun, he was a Southerner, and he responded to a tariff passed by Congress, a Northern-controlled Congress, who were more in favor of the Hamiltonian broad constructionist view, in which this Northern-controlled Congress passed tariffs that imposed taxes on goods such as barrels and shovels and picks. Goods made in the North would receive this protection from this tariff because goods coming in from outside the country would now have this tax superimposed on them. So the Northerners could charge more for the homemade barrels here in the United States and shovels and picks and farm equipment than they could otherwise. And so the way he saw this was making the North rich and the South poor. At the time, there was even a political cartoon where you had one skinny guy and one hefty guy, and that was the argument, that the South was becoming skinny and weak, and the North was just becoming fat and rich. And so he argued very much what Madison and Jefferson had argued in the Virginia and Kentucky resolutions, that states have the right to declare those laws that they deem unconstitutional within their own borders to be null and void. So you would have thought that McCulloch versus Maryland would have settled the issue, but it did not, because here, just 5 years later, you got John C. Calhoun basically, again, arguing for the same type of interpretation that was rejected by the Supreme Court in McCulloch versus Maryland. We will end this video there. I'm almost out of time. Pick up with the next one.